Nashville?
I am indeed.
Right.
It's nice to see everyone.
Good to see you. Thanks for being on.
Absolutely.
And Preston Eric will join us after you.
I would anticipate him jumping on momentarily.
Okay. And when we, after your presentation, would you mind introducing Eric?
Certainly, sure.
Okay. Thank you so much. Okay. It is 4:01. I think everyone's here. Tara Callahan, are we going to see your pretty face today?
How about I do the next one video?
Okay, well, welcome everyone. Really happy to have everyone here in the Working Group 3 meeting today. As you know, we have tackled a lot of issues, and I think we're making some great progress. We've talked about the racial equity training for court officials. We've looked at the overcriminalization of charges and city ordinances, bail, first appearances, diversion programs, pretrial services, the use of citations instead of warrants, and failure to appears. Today, we're taking a big shift into the entry of our system and discussing juvenile justice issues, what is commonly referred to, somewhat appropriate or not, but it's the pipeline from being very young children into our prisons. Some call it the school to prison pipeline. I don't like to offend schools by saying the schools are causing this pipeline. But anyway, we have some wonderful guests. We got a lot to go over. Please ask questions, take notes. And before we start, I think Natalia has some logistical things she'd like to mention.
Hi, everyone. Good to see y'all. I know as we kind of delve into the meat of this work that we're asking a lot out of everybody, and you know, it's time consuming. So thanks in advance for continuing to stick with it. I think as we're kind of tackling some of the recommendations that are more technical or more difficult, that we just really need everybody to continue to stay engaged. For the bail recommendations that we talked about last week, I know a couple people haven't given feedback for those yet. So there's still an opportunity because we're slowing down with those to make sure that we get them right as we can. And then one particular ask of y'all, so you've probably gotten links to surveys from Ellen. And the purpose of those surveys is really because at our next task force meetings, we're going to have a lot of issues on the table. And so it's going to be hard to have a lengthy or robust discussion on each one. So we're using the surveys to identify kind of where people already have an understanding of a proposal, where they need more information, so that we can, you know, incorporate feedback or reach out to people to provide the information that they need to be able to consider a recommendation. So it shouldn't take you long to go through the survey. So just look for those and make sure you respond to them. This week, we had some of our recommendations on the survey, and I think those were adopted unanimously, but if you can still just go through and fill out the survey, because in theory, we could be presenting recommendations that don't have unanimous support. So we want to make sure we know kind of where people stand. So that is all. And if we're ready, I can go ahead and turn it over to our first speaker, who is Billy Lassiter. He's the Deputy Secretary of Juvenile Justice in the Department of Public Safety, here to talk to us about the juvenile justice system. I know that he cares very deeply about improving racial equity in that system and has some potential areas for us to consider in terms of recommendations. So I will turn it over to Billy. Thanks for being here.
Thank you, Natalia. It's good to see you again. And thank you, Chairman Moray. And I always call her Judge Moray because that's how I first met her and many years ago. And I know that she spent many years working on these issues. Y'all hear me good?
Yeah, you sound great.
I'm going to share my screen real quick and pull up my PowerPoint. hopefully, can everybody see that? Okay. And so I thank the committee and for volunteering your time and expertise into making our system in the state of North Carolina a more equitable system for all our youth and for our adults across the system, and really appreciate all the work that you guys are doing on this. I've got a PowerPoint today that I want to share with you to kind of give you an overview of what we're seeing in the juvenile justice system as far as racial equity issues. And then I've got a couple of recommendations that our staff have made as far as racial equity issues in the juvenile justice system. So I'll start out by kind of giving you kind of the overview of where we are with the juvenile justice system as far as the numbers and what it looks like as far as a racial breakdown. And you can see in this first slide here, it really talks about, we broke it down into two different characteristics today. We looked at youth of color, which would be all groups that are non-white members of our society, and then African-American youth. And so those are the two categories that we kind of broke it down into. And what we have found, and for the research, is really that as far as equity issues, as far as disproportionality of involvement in the system, this really tends to be much more of an African-American issue than it does any other racial issue as far as the juvenile justice system. And I'll show you that as we're going through the PowerPoint and give you a good understanding of why I say that. So, but I do want to show you the overall look at it to start out with, and that's the youth of color. And you can see that although youth of color make up only about 46% of our population, they accounted for 71% of complaints received. So in the juvenile justice system, if you're not very familiar, we call a entrance into the juvenile justice system a complaint. And so that's why you see the complaint numbers that are listed first there. Our next real deep end part of the system is the detention system. And so again, 46% of the population is youth of color. 81% of those kids that were detained in detention centers last year were youth of color. So almost twice of what they would make up in society as a whole. And then 80% of our youth development centers. So youth development center commitments are the deep end of our system, where kids get sent to as a dispositional option by the court. It is the most deep end that a kid could get into the system. And so you can see that they're almost, again, double what you would expect based off the population. And then the statistics right below that show specifically just the African-American population. So 24% of the population in the state of North Carolina are African-American youth. 55% of all juvenile complaints that came into the system were on African-American youth, 65% for detention, and also with our youth development center commitments. So I broke this down into those different areas. And so you can kind of see those different populations. And so complaints is the first category. So a complaint would be when a kid gets arrested by a law enforcement officer. It's the typical way that a complaint's filed. So almost 85% of all juvenile complaints that came into the system last year came from a law enforcement officer. That doesn't mean that the law enforcement officer was the one that necessarily initiated the action. It could have been a private citizen. It could have been a school that called a law enforcement officer to make the arrest. And we get those arrests in as complaints. They file a complaint with us. We turn that complaint into a juvenile petition when it goes to court. And so you can see the numbers here as they break down. So 29% of all complaints that came into the system last year were for white kids. Then you've got 55% for African-American kids. And you can see right beside that how they break down as far as a percentage of the population as a whole in our society. So the reason why I said that it really looks like this is mainly an African-American issue that we really need to do the most work on is because you can see with the Hispanic population, they actually are underrepresented as far as complaints. They make up 16% of the population, but 11% of the complaints that came in last year. But what I will tell you, and you'll see this in future slides, is that Hispanic population has been growing greatly in the juvenile justice system, especially with Raise the Age just being passed. And we'll talk more about what Raise the Age is in just a second. The next slide here shows court approvals. So in the juvenile justice system, unlike the adult system, the court approval process is done by a juvenile court counselor. Juvenile court counselors serve almost as the magistrate of the system for juvenile justice. So they're hired by our department. They work for us. They're certified employees, and they make determinations based off an intake hearing that they are meeting conference that they have with the youth and the family, they determine what happens next with that complaint once it comes in from law enforcement. And so you saw the disproportionality that occurs based off arrest. And then the next step in the system where that disproportionality can be cut down is when they get an actual decision on whether or not a case should move forward or it should be diverted or closed. Those are the three options that a juvenile court counselor has. And the decision of that juvenile court counselor can be reviewed by a district attorney and they can overrule the decision. But very rarely does that happen. Last year in the state of North Carolina, that was only done 12 times. And so typically the decision of the juvenile court counselor stands as far as whether a case is approved, diverted, or closed for court. Now there are certain offenses that are non-divertible. Those would be all the A through E offenses. They are all non-divertible, and substance abuse offenses are also non-divertible. And so those are cases, felony substance abuse offenses are non-divertible. So those are cases where the juvenile court counselor has no choice but to approve that case to go to court in those particular incidents. Every other incident that comes into the court counselor's office, they can make a determination about whether to divert or close or approve those cases. We do that by doing a risk and needs assessment on every child and determining what needs to happen next with them moving forward. And so you can kind of see, again, African-American youth are overrepresented as far as cases that are approved for court. And there could be several reasons for that, that might be driving it. It could be that they're getting more of the non-divertible offenses. It could be that they have less resources that are available to them, meaning that they may not have private counseling available, for example. And so when they come into the juvenile court counseling office and they desperately need services, it's more likely that our staff could approve that for court because they need the court to help refer and get those services so that those services can be paid for that juvenile and their family. And so those may be some of the reasons that we're seeing that higher approval rate for those African-American youth. The next slide shows you diversions. And again, you know, we divert in the state of North Carolina, we divert almost 20% of all cases that come to the juvenile court counselor's offices. And so that's 1 out of every 5 complaints that is filed on a juvenile, we divert. When we say divert, what does that mean? It means that they still go under a form of supervision. We call it a plan or contract with the juvenile court counselor. They come up with a plan with the family and with the child, and they determine what needs to happen as far as services or restitution or restorative process that needs to occur. And if the kid follows through with those diversion plans or contracts, then they never go to court. In fact, their case is completely closed out and they're removed from the system as far as having involvement with the juvenile justice system after that plan or contract is completed. And so you can see that 20% were approved for a diversion plan or contract, but for African-American youth, it was slightly lower. It was only 15% of those juveniles were approved for those diversion plans or contracts. And then the last one is closed. Closed means that typically there was not legal sufficiency to move forward with the case. And so our juvenile court counselors would make the decisions to go ahead and close that case outright, or there may not have been a crime at all that was committed. You know, we get a lot of complaints from people in the public that want to complain about a child and not necessarily any legal sufficiency to move forward with a case there. And so we completely close those cases out. They don't move forward at all, and that kid is removed from the system. So actually with this particular category, we actually see that African Americans actually get more cases closed than any other race. And so what would that mean? It means that typically we're getting more complaints on African Americans that are not legitimate complaints. They don't have legal sufficiency to move forward. And so our office is pretty good at catching those and saying, okay, we're not approving this for court. We're not even putting this on a diversion plan because there's just not enough evidence that anything happened here, or this is not something that is actually criminal. This is something else that's going on that needs another type of service for this child. And so that is a good sign for African-American youth in that particular regard. Let's look at complaints by race. And so this gives you a time period chart here. This goes all the way back to 2008. Extremely interesting. And I think it's important for people to understand when we're talking about juvenile justice, we've done an outstanding job really in this state of reducing juvenile complaints. this dates back to the way back in 2000 when Judge Moray was on the juvenile task force that looked at reforming the juvenile justice system in the state of North Carolina. Governor Cooper at that time was a state senator and chaired that committee. And we made a huge changes to the juvenile justice system in our state. And it's reaped outstanding rewards for our youth and for our state, and lots of cost savings for our state. And so you can see that in this chart here, the overall trend here is that juvenile complaints just since 2008 are down 37%. The only rise in that last little part of the chart there is because of Raise the Age. Raise the Age was when we started to allow 16 or 17-year-olds to come into the juvenile justice system. So that's why you see that last little uptick at the very end there, is because we have let in, for that last 9 months of that particular year, started to let in that older population. It's not because the actual juvenile crime rate was going up. And so I just want to make that clear, but I did want to show you that uptick because I think it's important as we go forward with this conversation, because where we're seeing the greatest racial disparities is among that 16 or 17-year-old population. And that I would contribute to the fact that we haven't had as much time in the juvenile justice system to adjust our tools to make sure that we can remove racial equity disparities in the system with that population. So complaints are down, which has been good for all races. You can see Hispanic population is the only one that's showing that it's up, and that's up 24%. But if you were to remove the Raise the Age population, there would be no decrease for the or increase for the Hispanic population. So that's completely related only to that Raise the Age population. But I did want to let you see the full chart there, because this is really good news. And I hope that you'll go back in your community and tell people that juvenile crime in the state of North Carolina is down, and we actually are doing a really good job of continuing that trend. The next chart here just shows you by race how complaints have decreased. And so the point here is that although we've done a really good job of addressing reducing juvenile complaints coming into the system, there still continues to be this constant racial disparity that exists between African-American juveniles and white juveniles across our state. And we really have not been able to, that rate stays stubbornly high as far as looking at what is the actual disproportionality that occurs in the system. So this kind of just shows you over time what that rate looks like. And again, that last little bullet point is after Raise the Age, and that's it's not a true comparison with the rest of the data, but I just wanted to show it to you because it's interesting, because it's showing us a new trend line for that new population that's coming into the system. The next one is detention admissions. So detention is typically for kids that are awaiting trial. This is in our state, if you're familiar with the adult system, this would be the equivalent of jail. So these are for kids that are awaiting trial, but it can also be used as a dispositional option by the judge. One of the things that the judge can order for level 1 and level 2 is a certain number of intermittent confinement days. We have been working extremely hard in our system to reduce those days because we feel like that kids are better served in the community and staying connected with their families and their schools. And so we've been working really hard on reducing detention days. And you can see we've been very successful at reducing those detention days over the last decade here. So this goes back to 2008 also. And you can see that huge drop off in 2010, 2011, and 2012. What happened in those years is we got a MacArthur grant to work on detention confinement and trying to reduce detention confinement among kids that didn't really need it. And that was very successful. And one of the things that we built out of that was a detention assessment tool. And that tool measures what the risk factors are of a kid really needing to be confined while they're waiting for trial. And that's what's caused this huge drop off in the number of detention admissions. And so you can see that this has been really good for all races, better for white kids than it is for African-American kids, because we've seen an 80% drop off in white kids getting detained. But it's also been a 67% drop off for African-American kids. So really has been good for all kids across the system, but slightly better for white kids. And so the next slide kind of shows you that same overall, what does the trend line look like as far as the percentage of kids that are going into detention. And again, it's been stubbornly high that we cannot get that change that we're looking for as far as the percentage of African American kids coming into the system that get detained versus white kids. And although it's always important to look at the context, because still with African American kids, you've seen a 67% drop in the overall number of kids being detained. And that's really important for lots of reasons, but one of the big ones is that what the research has now shown is that kids that are detained are much more likely to get recidivate back into the system, both as a juvenile and as an adult. So we want to try to keep kids out of the detention if at all possible. So one of the tools that we put in place was the detention and screening tool that I was telling you about, assessment tool. And this is a tool that we put in place in 2012, but we started piloting it all the way back in 2010. We actually went to every jurisdiction in the state, met with the chief district judge, and we had stakeholder forums. We invited law enforcement, judges, and community members together to say, these are your numbers. This is the number of kids you're detaining in your community. How do we reduce that in your community? And so the detention assessment tool was one of those things that we developed out of that process, and it gives a standardized, consistent way of looking at this, and it tries to remove the bias out of the decision by looking at the number that is added up instead of looking at the race of a child. We can determine whether or not a kid needs to be detained in the system. And so it's a structural assessment tool that we've put in place. It's in working in every jurisdiction. Every kid that gets detained must have the detention assessment tool completed before they can get detained. Now, it can be overridden by the chief court counselor or by the chief district judge, who ultimately can make the decision that a kid can be detained, even though the tool says they should not be. But what we find is that in most part, the judges and the chief court counselors are going along with the decision of the detention assessment tool. The benefits to the state is that we get that consistency across the system. It's a structural decision-making tool. It takes some of that bias out of it. It helped us also think through a greater continuum of services that will be available for these kids. If we're not going to detain, then what are we going to do while we're waiting for them to go to trial? What are the other services that are available in the community? And so we enhanced that continuum of services for those kids, improved other juvenile justice system outcomes overall for our kids. It saves the counties a lot of money, and it saves the state a lot of money. And just to kind of paint you a picture of that, it costs $244 a day to put a kid in detention. Over the last year, if you were looking over a decade, we've reduced the number of detention admissions last year by over 3,000 kids. And so you're talking about 3,000 times $244 a day for the length of stay that a kid is in detention. And we've been able to take those dollars and reinvest those back into communities through our Juvenile Crime Prevention Council programming. And that was one of the big selling factors that we used when we talked to the General Assembly about why they should raise the age. Is because look at the cost savings that we've been able to produce with this younger population and how well we've reinvested those dollars back into communities to keep kids out of the system moving forward. And they bought into that, that argument moving forward. The next one is youth development centers. So again, youth development centers would be the equivalent on the adult side of what you would think of as prison, but is not relatable at all. Youth development centers have very different services for kids than you would think of in an adult system. We provide educational services for every child, mental health services for every child, recreational services, and everything that needs to go into making sure that that child can be a successful citizen when they leave that facility. Last year in our youth development centers, 100% of our kids had a mental health diagnosis when they walked in the door, 100%. The average kid, meaning over 50% of them, had 5 or more mental health diagnoses. So the services that we have available in those youth development centers are intense, they're expensive, and I don't apologize for that, because when you have a kid that has 5 mental health diagnoses, they're on average 5 years behind on their educational services. They need intensive services. And so the services that are provided in these youth development centers give those services to those kids. And we often see great progress when they're with us. But the point that this slide shows you is that we've really reduced that youth development center population. When I first started working in juvenile justice, these numbers are from 2008, it's 452. When I first started working in juvenile justice, we had over 1,500 kids in youth development centers. Today, you can see the total number there, 140. That is a huge drop in the number of kids in our youth development centers, and it's helped all races, but it's helped African-American kids the most. You can see that they've dropped 75% in the number of kids, percentage of kids going to youth development centers in comparison to just 2008. If we went back farther than that, that number, if you go back to 2000, that would drop by 90%, the percentage of African-American kids being put in youth development centers. So really positive statistic there as far as what we're looking at as far as that population. The next one, it shows you the breakdown as far as the percentage racial breakdown of what it looks like for kids in our youth development centers. Again, although we've seen a huge drop in these populations, it's been a very proportional drop. All races have gone down kind of at the same time. And so you're not seeing a huge drop off in the disproportionality of the races in those facilities. JCPCs, if you're not familiar with what a JCPC is a Juvenile Crime Prevention Council, and every county in the state of North Carolina has a JCPC. And on our website, you can get a listing of every member that's a member of the JCPC in your county. The JCPCs decide on how dollars that are sent from the state are going to be used locally to prevent juvenile crime and to put in place diversion programs for kids that are involved in the system, or kids to keep kids out of the system, and more intensive programs that need to be involved in the local communities. And so you can see that we really try to encourage diversity in those programs. This may be one of the areas that a recommendation could be made to give the department more power to, if a county is not achieving diversity on their JCPC, that we could really go in and say, if you don't do diversity, if you don't have the right membership on your JCPC, then you would lose funding for that. And so that would be one area that we could look at, because right now we encourage it, but we can't do anything about it if the county chooses not to do diversity on that JCPC. As far as JCPC programs, this shows you the breakdown of how kids are being served in those JCPC programs. And one of my big things that we've been focusing on is making sure that the kids that need to be served by these dollars are the kids that are getting served by these dollars. So if we're going to spend money on juvenile crime prevention, then we need to make sure that African-American kids that are more at risk of going into the system are getting those services, so that we can avoid them getting into the system. And you can see that African-American kids are getting more access to the services than as a proportion of society. And I think that's a really good thing as we move forward. So JCPCs across the state of North Carolina last year served over 20,000 kids. And one of the things that we're asking for them to do in their annual planning process now is to prove that they're putting programs in locations where the most at-risk kids can have access to those programs. So if, for example, if you're starting a new program for juveniles and it's in the far rural part of the county, and most of your kids in the juvenile justice system are in the inner city, that doesn't make sense. And so we want to make sure that the services are close to where the kids themselves are in the system. So the next thing I wanted to look at was one of the big factors that we found that make a decision about whether or not a kid moves forward in the juvenile justice system or whether they move forward in some other system is mental health outcomes. And what we find is that kids of color are treated differently in the mental health system than white kids. And I think this tends to cause African-American youth to get treated more harshly in the juvenile justice system or in the adult system, probably later in life, because what we're finding is that African-American kids are much more likely to get diagnoses that are ones that are externalizing versus white kids getting diagnoses that tend to be more internalizing, meaning like trauma are things that are often looked at with white kids or Caucasian kids, where with African-American kids, it's typically oppositional defiance disorder is the most common diagnosis that we find on African-American kids. And a lot of times, because that is an externalizing diagnosis, they're still treated, most people still see oppositional defiance disorder as just a mean kid. And so when you get that diagnosis, it often, when it's presented to the judge, it's not treated as something that needs as much treatment as it is something that needs to have some type of consequence for that behavior. And so we think this is one of the areas that we really need to look at is, why is that happening? Why are African-American kids more likely to get diagnosed with these externalizing factors, and white kids more likely to get the internalizing factors? And so this shows you the kind of the breakdown of that. This comes from data from NC TOPS, which is the mental health system's way of tracking data. This is just juvenile justice kids that have come into the system. And you can see the percentage of juvenile justice involved youth that are showing externalizing diagnoses. And for African-American kids, it's 75% versus white kids, it's only 63%. And so there's a big disparity there that's occurring. And that's one of the factors that we really want to look at is what's causing that to occur. And kind of the inverse of that is the internalizing ones, which are depression, trauma, and those types of things. You can see the disparity there is in the exact opposite way. School-based complaints. I know this was another big area that that you guys are looking at or are going to consider. What is a school-based complaint? Is a complaint that occurs on a school campus or a school-sanctioned event or on a school bus. And so typically it is the most common place that a juvenile complaint is filed is on a school campus. And you can see it's about 40% of all juvenile complaints that come into the system are school-based offenses. But again, we've seen a negative or down decrease of all juvenile complaints. And that's also been true with school-based offenses. School-based offenses in the state of North Carolina have been going down and have been going down very significantly over the last 10 years. And so I know one of the things that people are really concerned about on the task force, I've presented to a couple of the other subcommittees, is the role of school resource officers. And one of the things that I would say about that is that I would say the jury's still out, whether the school resource officers are the factor that drives school-based offenses. Because what we have seen is that as school resource officer numbers have actually increased on campuses, our school-based offenses have actually gone down, which is the opposite of what most people are saying that they think is happening as far as school resource officers being on campus. Now, I can't prove that because I can just tell you those are the two trends that we have seen. And are there definitely things that need to be done to enhance school resource officer training to make them a more important part of the resources on school campuses? Absolutely. And we'll talk about a couple of those in just a minute. But I think it's wrong just to say that that's the one factor that has caused school-based offenses to occur in our schools, because we've actually seen the opposite. As those officers have increased, the number of school-based offenses have actually gone down. This shows you the trend lines for different races on school-based offenses. And so we've actually, again, we've seen pretty large decreases in the number of school-based offenses for all races. And actually African-American youth have actually seen the biggest decrease over the last decade, 56% decrease in the number of school-based offenses that have been filed against African-American youth. And so again, I think this is a very positive sign. What's causing that? Our school justice partnerships that we put in place across the state, a huge focus by our department with schools and law enforcement to say there's a better alternative to filing a juvenile complaint on a kid that's just showing school disciplinary problems. And so having that conversation and moving that forward, I think has really led to us seeing some of these reductions that we have. Is there more that we need to do? Absolutely. There's still a lot of the offenses that come in from school-based offenses are minor offenses. The top one being simple affray, meaning a small fight where nobody got hurt. When I was in school, you didn't get charged for that. And I really think that we need to look at as a society, why is that occurring? Why are we getting those simple affrays coming into the juvenile justice system versus having that handled in a better way in the community? And this shows you the school-based by race, how it breaks down, the percentage again, and gives you that trend line over time. And again, not a huge change for any of those groups as far as proportionality. It's an overall drop in the number of complaints that have occurred in the system over time. The minimum age, want to hit on that also. So North Carolina has a minimum age, meaning that you can be charged in the state of North Carolina at the age of 6. I'll say that one more time. You can be charged in the state of North Carolina at the age of 6.
Really about 3 more minutes or so.
Okay, great. So the minimum age in our state is the lowest in the country. Now there are quite a few states that don't have a minimum age at all. And so just want to give you some statistics on that. We do a pretty good job of keeping these kids out of the system under the age of 10. It's only about 1.5% of all juvenile complaints that come into the system. And you can see most of those are for school-based offenses. 70% of them last year were school-based offenses. If you look at age 12, and that's one of the decisions that you guys may want to look at is, should we move, if we change the minimum age, should we move it to 10? Should we move it to 12? And so I gave you the breakdown for both of those. So you can see the breakdown of how that occurs in the system and how the racial disparity occurs. So with the really young kids, you're much more likely to be an African-American kid. It starts to drop off a little bit when you raise it up to 12. As far as the top offenses that we see for this population under the age of 10, it's assault on school personnel is the number one. Simple assault is number 2. Assault on a government official, and then disorderly conduct at school, and then communicating threats. All of these are school-based offenses, every single one of them. And so the question is, what resources need to be there to deal with these types of things that occur? My wife is a speech therapist, works at elementary school, and I can tell you that a lot of her kids are autistic. If she were to charge every kid that hit her, there'd be a million charges coming, because those kids can't help it. It's part of their disability. And so we really need to think through, is there a better way to handle those types of things and understand what we can equip teachers and school personnel with to make this work. I'm gonna hit on one more issue real quick that I think it's important. That's transfers to Superior Court. And so transfers to Superior Court is basically saying, these are kids that were moving from juvenile jurisdiction up to adult jurisdiction because of some type of offense that they did that we think is so bad that they can't be handled in the juvenile justice system. Under Raise the Age, there's an automatic transfer for A through G offenses in the code for 16 or 17-year-olds. And so the red bars here show you the Raise the Age population, and you can see how that is very disproportionate for African-American kids. Much more of the African-American kids are getting transferred to Superior Court than the other races. And so 119 kids already this year under the Raise the Age provision that allow for that automatic transfer for A through Gs. For that real quick, these are the complaints that are coming in on those Superior Court offenses. So you can kind of see these are the top offenses that are being transferred. I won't spend a whole lot of time on that because I know I'm almost out of time. And then I just wanted to show you the most serious offense that they occurred that caused them to get transferred. So a lot of them are for D felonies, but we are getting ones for E's and F's. The original recommendation that came out of Raise the Age from the Chief Justice's Commission on Raise the Age was that we should only transfer A through E's automatically. So the F's, G's, H's, and I's would have not been automatically transferred, and H and I's are not, but they are discretionary transfers for those particular cases. Let me hit these recommendations real quick and I'll wrap it up. So our recommendations, we're currently doing some studies on SROs because I know that's one of the issues that you guys are looking at. We're looking at the elementary SROs, and so far what we have found is like I described before, simply putting a school resource officer in a school does not necessarily increase the number of juvenile offenses on that school campus. In fact, we found that where SROs had gone, we actually saw a reduction in school-based offenses. There needs to be more research on this to look at whether that's a true trend or if that's just because of the particular locations that just hired those elementary school SROs or not. We're doing research studies with NC State right now to look at racial disparities by geographic areas. So we'll get more information about that. And one of the things that we're looking at is, are they charged with more serious offenses for the same types of crimes that are being committed in those local areas? So recommendations, we think that there needs to be more diversion programming for kids that are for school-based offenses, more money that can be put into the school justice partnerships so that if local school districts and communities want to partner together to think of ways to creatively keep kids out of the juvenile justice system and out of alternative schools or out of school suspension, we'd have resources for them to do that. We want to look at the minimum age with services. I think that's the big part of this is many are concerned if we don't allow these kids to have complaints filed on them and go in the juvenile justice system, how will they be served? And so what types of services can we put in place? How can we recommend that? Review the transfer to superior court policy. One of the things that we found that I kind of skipped over one of the slides pretty quickly on there is that a lot of the African-American kids are almost automatically being transferred to adult court for these A through G offenses, while the white kids are not. They're sitting in juvenile detention and their case is being debated before that decision is made. And so we've seen very few white kids, although they've committed almost as many offenses as African-American kids, they're still not being automatically transferred from the very beginning, although that is required by the law. And I think that's because we're looking at plea bargains and other ways that they can maybe move them down so they don't end up getting transferred. Reporting requirements, we think that juvenile justice should be the ones that are in charge of putting together the annual studies on racial disparities and making recommendations. Right now, that lies with the Governor's Crime Commission and a committee that they have set up that hasn't had a lot of oomph behind it. I'll just put it that way. And we really think that if we brought it up to this level on our department's side in juvenile justice, we could get the players to come to the table, have a real discussion about racial equity in the state, and put some resources where we have a problem. And so we'd like to look at moving that reporting function from the Crime Commission over to juvenile justice to make that happen. I promise I got only just two more. Right now there's a requirement for juvenile justice minority sensitivity training that's required for law enforcement. It's also required for our juvenile justice staff. A lot of times the training has nothing to do with racial disparities that are occurring in the system and has very little to do with what would be important for us to be teaching our staff. We'd like to have authority over that in our department to allow for us to have more emphasis on racial equity problems that are occurring. We'd like for this subcommittee, I'm not sure exactly if you can make recommendations on resources, but we would love for you to make a recommendation that all our staff could be trained on REI, which is the Racial Equity Institute's training that they do. It would cost about $100,000 to train all our staff. And so we'd really like to go ahead and do that as soon as possible. And so any resources that could be recommended for that purpose would be one that we'd like to do. And the final one is that we'd love for the Safer Schools Task Force to be charged with putting together some consistent rules about how discipline should be handled across the state of North Carolina for school discipline problems, and partner with DPI, Juvenile Justice, the Department of Health and Human Services, and Mental Health, bring all those players to the table and let's have a discussion about how do we handle this, how do we share responsibilities across the state of North Carolina to properly discipline children. And I've got a couple last slides that are on there that I won't go through, but they basically talk about other recommendations that are coming out of the Safer Schools Task Force on training that is needed for school resource officers that you guys can look at later. Thank you so much. Sorry for going over.
Thank you. Thank you very much. Are there just any compelling questions that you have for Billy right now before we move on to our next speaker?
Karen, I think we should move on, and then I don't know if Billy can stay on if we have time at the end, come back. But Billy, you gave us a whole lot of information. It was fabulous. I know your staff worked very hard on that, and you gave an excellent presentation. And before you go, congratulations on your Defender of Justice Award this week. Well deserved. Billy's getting a state award as a Defender of Justice, and so really great honor. Anyway, if we could move and keep going. Jackie Green is here with the School of Government. Jackie's been with School of Government since 2018, focusing on juvenile justice matters. She came from the state of New York, where she worked with the governor's office for 15 years on juvenile justice issues, was executive director of Youth, Public Safety and Justice. She's a graduate of UNC and a little known law school called Harvard. And we're glad she came back to Chapel Hill and UNC. And Jackie, we welcome you Please go ahead.
Thank you so much. It's really great to be with all of you today. I'm just going to share my screen with you. I have a couple of slides, just, I promise, not a lot of slides. If it will, yeah, run for you. So I have only 10 minutes with you. And in that 10 minutes, I want to highlight two things. One, I just want to pull back from a lot of the detailed data that Billy provided to you and show you a couple of graphs about kind of where we are right now in racial and ethnic disparity in juvenile justice. And then I'm just going to give you a little bit more about this transfer process that Billy talked about, how that changed in Raise the Age and what that looks like now, and maybe that helps understand a little bit what's behind the trends that Billy was talking about. So I published a blog on one of our School of Government, our criminal law blog, and our civil law blog a couple of months ago that took the most recent DMC disproportionality assessment that North Carolina, that Governor's Crime Commission funded. So this data, I think, is 1 year older than the data that Billy shared with you in his slides. But this graph, I feel like just speaks volumes. Well, you know, as Billy emphasized, volume has gone way down. So the raw numbers of kids who are impacted by this is way down across all racial and ethnic groups. There's still pretty tremendous disparity. So this is just Black youth. And you see on the bottom, they're 24% or so of the overall population of young people in North Carolina. But over half of the population of kids for whom complaints are received in the juvenile justice system. And you see that disparity persist throughout the processing. And then by the time you get to who is actually getting committed at the very deep end, so those YDCs are, you know, secure confinement structures. They're nearly 3/4 of the kids who are in secure confinement, at least they were. I think Billy's number was down in the 66 maybe percent or something like that in the most recent year. But it's still a stark disparity when you walk back to look at their representation in the overall population. And this is a different frame of reference, and we don't have time for me to fully explain to you what a relative rate index is, but this is a measure that the Federal Office of Juvenile Justice and Delinquency Prevention had been using for a couple of decades for states to measure racial and ethnic disparity in their juvenile justice systems. And it basically compares all minority groups to white kids. So rates, the rate of involvement at each system point for each minority group compared to the rate for white kids. So the white kids are a 1, and if you're above a 1, that's like how much greater your rate is than white kids at that point in the system. And the analysis builds on itself. So you start with complaints received, and you see this graph tells you that Black kids were over 4 times more likely to be represented in the complaint received stage, the very front end of the juvenile justice system, than white kids were, because they are the 1. And when you move to the second piece here, secure detention, that analysis is based on the numbers in the first piece. So it's supposed to show you if disparity is kind of growing or shrinking as they move through the system based on how many kids were at the last system point. And so the thing I would just draw out for you here, both with this slide and this slide, is it seems like in North Carolina, our 2 kind of greatest points of disparity are at the very front door of the juvenile justice system, who's getting brought in by the police in the first place, and in this very, very deep end of who is ending up in the most secure confinement. The front door and the very, very deep end kind of back door is what jumped out for me. And if you are interested in more details about those numbers, or there's a little bit more detail in the blog I posted, and here's the link to that. So let's talk about transfer. So this is the process that exists now and existed prior to Raise the Age for kids who commit their offenses between the ages of 13 and 15. And so this is what the process has been in North Carolina for a long time for these kids. That involves, you know, you file a juvenile petition, there has to be a probable cause hearing, then there has to be a transfer hearing. And we have a law that says the judge has to consider 8 factors in making a decision about whether or not to transfer the case. And for these 13 to 15-year-olds, that is the process for any felony offense, except that if there is probable cause found for a Class A felony, those cases have to be transferred, right? But that's a Class A felonies. It's a, very small number of felonies, and that ends up being a very, very minute number of cases. And the reality was that very few cases in North Carolina, year in and year out, get transferred under this structure. It wasn't something that was happening in great number. Well, with Raise the Age, we changed the process for people who are charged with felony offenses at age 16 or 17. So for them, if their most serious charge is an H or an I felony, they are subject to that same discretionary transfer process that I just talked about for the 13 to 15-year-olds who are charged with anything other than a Class A. There's a probable cause hearing, there's a transfer hearing, and there are 8 statutory criteria on which the judge can decide whether or not to transfer the case. But the big difference for the 16 and 17-year-olds is what happens for the A through G felonies. So if they have a matter in which their most serious charge is an A through G felony alleged to have been committed at age 16 or 17, it's a completely different process, and it is automatic, as Billy described. And it's automatic in one of 2 ways, and the prosecutor gets to pick. So it could be that you do the whole probable cause process, and there's a finding of probable cause, which would require a hearing or an admission. But in addition, new wrinkle under Raise the Age, this transfer process can be triggered alternatively by the return of an indictment. So this was the first time ever that the indictment process was tied in any way to what is happening in juvenile court. And the extent of the law on this is about 2 sentences in the Raise the Age legislation. There's very little direction in the new law about what this process is supposed to look like. We know there's supposed to be some kind of notice, but it doesn't tell us notice of what, and a finding that an indictment was returned that alleges an A through G felony at 16 or 17. And if that finding is made, then the case has to be transferred, no discretion. And the statute does not even say that you have to make that finding at a hearing. So it has become, and I get lots of questions about this more and more every day, it feels, about how this process is supposed to work. And as I listen to those questions, I hear people talking about prosecutors getting indictments before anything has happened in juvenile court. I hear about prosecutors getting indictments, and maybe there's a mistake because the top charge was actually not an A through a G. The top charge was an H, but the judge signed the transfer order and the case was automatically transferred. Mistakes can be made. I think people feel like, oh, this is so clear and easy that we didn't really need much process around it. But I feel like, in the questions I'm getting, that there's a lot of confusion. And because the indictment process is the normal way that you start a case in the criminal system, it seems like in some cases, this almost feels like business as usual, as if we hadn't raised the age. Because the prosecutor's just going to get the indictment, just like they would go to get the indictment before. And then there's almost what feels like just a paper process of a shuffling of papers in the district court matter, and the transfer order is signed and it's a superior court case. And it's interesting that Billy mentioned that seems to be happening more quickly for kids of color, because as I've trained a lot of prosecutors on Raise the Age, I often get questions about, well, wait, we might not always want actually to transfer, say, a G, which common law robbery is an example of a G felony. We might not always feel like that transfer is appropriate. What can I do? And my advice to them is always, well, you got to work it out before you have a finding of probable cause or an indictment returned, because once one of those things happens, it must get transferred. So if you want to keep it in juvenile court from the very beginning, it can't be an A through G. You have to figure out a lower charge in order to never move that case to superior court. And it's interesting to hear Billy say, it sounds like that kind of work might be happening for white kids more often than it's happening for kids of color, because the numbers on those transfers is pretty stark in its disparity. So I'm sure it's probably been 10 minutes and I'm out of time, but I just wanted to explain that to you, because it is it's in the weeds, and those of us that are in juvenile justice all the time are like, oh yeah, you know, the indictment process and mandatory transfer, and we throw this stuff around, and it could be confusing. But so I wanted you just to understand that there is actually this new transfer process for 16 and 17-year-olds. It applies to quite a large bucket of felony offenses, and it can be triggered by the return of an indictment. An indictment never before has played a role in the juvenile justice system, and we have very little direction in the law about how that's supposed to work, and what that's supposed to look like. And I'll stop there.
Thank you. All right.
Jackie, thank you very much. And
You're welcome.
I think that transfer and the indictment is something really important for us to look at. And I know Billy showed us the slide with that of 119 kids, African-American kids or kids of color have already been transferred. And should that indictment process be refined? So we will talk about that, but wonderful job. Thanks a lot, great expert. And we will get all the SharePoint documents but if you can stay on, that's great. I know we have two more presenters, and this is, I think, one of the most important topics we can address, and it's juvenile life without parole. And it's, are we following what the Supreme Court has mandated for states to follow? Where is North Carolina right now in sentencing a child 13 up through 17 to life without parole? We have some experts here. Ben Fenhold is here. I hope he'll have a few minutes to make a comment or answer questions. Preston Shipp and Eric, Preston's going to introduce you, but Preston's an amazing guy. He worked as an appellate prosecutor in Tennessee Attorney General's office. He started doing a lot of work in the prisons as a volunteer, and I think it became his passion as he met young people and wanted to help them, and eventually left to work on this issue of juvenile life without parole. He has joined the Campaign for Fair Sentencing and is the Senior Policy Counsel, and is going all over the country talking, and he came to the General Assembly. We introduced House Bill 755 to eliminate juvenile life without parole, and Preston did a great job talking to the General Assembly members, and we didn't get this bill passed, but we got it filed, and we're going to still work on it. But Preston, take it away. Thanks for being here.
Well, thank you, Representative Maury, and it's great to see you again, and to the other task force members. I just really appreciate you all inviting us to join you. It's nice to be talking to folks who don't live too far away from where I am in Nashville. So as Representative Maury mentioned, I started my career as a prosecutor. I worked for several years in the Tennessee Attorney General's office, thought that I was going to be a career prosecutor, did not lose a moment's sleep, imposing decades-long sentences against people who were very, very young, until my alma mater here in Nashville invited me to come teach a law class at a local prison. And that was really the first time outside of a courtroom that I had gotten to know folks who were incarcerated. And certainly when you're in a courtroom, you don't hear the details of their life. You don't hear about the trauma that they have sustained. And I started hearing those things week after week, going out to the prison to teach my class. And what I was confronted with was a group of people who, to each individual person, was profoundly, remarkably gifted. But many of them really had no hope of ever getting to prove it to anybody, because they were serving either life without the possibility of parole or a term of years that exceeded their life expectancy. So I was really struck by that. And of course, you can't think that way too terribly long and continue to make those arguments about people that you don't really know. And that moved me into the criminal justice reform arena, which is where I got to know Eric, who I'll introduce in a minute. But the U.S. is the only country in the world that will sentence a child to die in prison. Only here will we tell a 14 or a 15 or a 16 or 17-year-old kid that there's no hope for you, and you're basically gonna die death by incarceration. And when you stop to think about that, when you stop to think about what our values are, we claim to be a people who value stories of redemption and second chances. And then when you pause to think about, how this sentence is overwhelmingly being imposed against people of color. A Black kid is 10 times more likely to receive life without the possibility of parole than a white kid is. This is absolutely a racial justice issue. And I'm going to share my screen with you. Let's see here. I can figure out how to do that. Can you all see that map there? So what we have in the United States, we had life without parole. The U.S. Supreme Court has weighed in some monumental cases that essentially say that life without the possibility of parole, when you're talking about someone under the age of 18, is unconstitutional. It's cruel and unusual punishment, except in the rarest of cases. Rarest of cases meaning a kid who is permanently, irreparably corrupt. And of course, I don't know how you say that about a 16-year-old. I don't know how a sentencing court can make that finding. And as you can see from the map, neither do all these states. All the states in blue have abolished life without the possibility of parole for kids, or do not have anyone serving that sentence. And you can see, unfortunately, North Carolina, Tennessee, a lot of the states in the Southeast have not jumped on board this national trend away from sentencing kids to die in prison. But we have some states that we can look to as examples, like Texas and Arkansas, most recently Virginia, earlier this year, West Virginia. I think by the end of the year, Ohio is going to be on this map in blue because their Senate just passed a bill, overwhelmingly 29-4, Republican authored bill that would abolish life without parole for kids. I think in 2021, we'll see legislation in Maryland, I think Mississippi, I think Missouri, and of course, Representative Morey has already alluded to the bill that she sponsored in North Carolina. So let me stop the share there. I can make that map available to you all if you'd like to see it. But basically, I'll just close because I want to hand it off to my friend Eric and I'll introduce him. What I learned from teaching those college classes and what I've learned since I've been working for the campaign, is that this is the moral arc along which states are rapidly moving. And it's an acknowledgement that children are fundamentally different from adults. They have the profound capacity to make positive change, to overcome their worst moment, and we must never deny them hope. They all kids, even those who've committed violent crimes, are deserving of our care and concern. And especially when you're talking about such a harsh sentence that gets so overwhelmingly imposed against kids of color, this is absolutely imperative, and I go all over the country encouraging legislators, policymakers to really take a hard look at this. It's not going to solve systemic racism, but it's certainly an important piece of the puzzle to go ahead and say, we're not going to sentence a kid to die in prison. We're going to make sure that, if they can demonstrate rehabilitation, that they don't pose a threat to public safety, that they can go forward and have a second chance at life outside prison. So again, I'm happy to take questions or my information can be made available to you if you want some additional resources. I want to turn it over to my colleague, Eric Alexander, who I believe I met for the first time in 2012 at the annual conference for the Children's Defense Fund. He's just a dear friend of mine, and I'm so grateful to know him, and he is responsible for bringing me on board at the campaign. So I owe him really, I guess, a cut of my salary every month. But Eric, thanks for all you do. Take it away.
Start collecting today. Thank you, sir. Again, I'm Eric Alexander, and I serve as national advocate. I'm at the Campaign for the Fair Sentencing of Youth. My story is similar to that of much other youth sentenced to life without parole and de facto life sentence in your state. And, de facto being those sentenced to 4 or more decades in prison, which is essential to life sentence. While none of us had aspirations to become involved in the justice system, our early lives are marked by traumatic experience that ultimately put us on the path to prison. Every parent on this call will tell you that children are impulsive, often unpredictable, but they are children nonetheless. As shared earlier, statistics based on those who receive these sentences show that most, if not all of us, experience childhood trauma, both in our homes and in our communities. A personal example for me was witnessing my alcoholic father physically and verbally abuse my mother throughout my early childhood. I remember one particular evening when, my mom decided that, she was finally going to divorce my dad and leave. She had collected my younger siblings, and he appeared out of nowhere and, punched her. The blow sent her to the ground, and he commenced then to drag her through the mud. When she finally broke free, we drove to the police station where she filed a restraining order against him. And, that incident left me shaken to my core. Traumatic incidents like these scarred the teenager that I remember being. It led me to a day in 1994 when marijuana, alcohol, and a child's impulsivity with a still developing brain allowed me to participate in a very unthinkable crime. I remember how we sat around that morning smoking marijuana and drinking alcohol. The suggestion was made that we act out a scene from a movie, taking along 2 guns, one of which was non-functioning, and the other which supposedly had no bullets. The plan was to frighten, the store employee or anybody else who walked up, and we were going to grab beer and run. My part was to stand watch as my 16-year-old friend went inside what seemed like forever. I heard gunshots. He came running out. Curiosity compelled me to go inside, where I found the store owner, Mr. Cantrell, lying on the floor, unresponsive. I ran and we were arrested a few hours later. I was tried as an adult and decided to take full responsibility for my role in that crime. With a heart filled with remorse, I accepted 2 25-year terms to be served consecutively to avoid a life sentence. My co-defendant wasn't as fortunate. He took a life sentence plus 25 years to avoid life without parole. He was 16 years old then. Prison was not and is not an exceptionally friendly place to a young man coming of age. One like me who had zero involvement with any section of the criminal justice system. I witnessed and experienced things that no child should ever experience. Forced to grow up fast, it was tough to focus on doing the right thing, honoring the memory of the life lost and becoming a better person while living in fear and uncertainty. But like many other children that are currently serving these sentences in your state, I did it. Sadly, though, with years of minimum contact with people from the outside, I'm a witness and a living example that children have a unique capacity for change. In spite of the violence, often occurring depression, and the fact that our sentences will outlast our lifetime, we dream of a chance to correct the errors in our judgment. While growing up in prison, I matured, denounced my gang membership, earned my GED, and became a licensed barber. I studied psychology and child development. These classes helped me to understand the impact of the trauma that I and others had experienced. This new understanding helped me to then counsel others into denouncing their gang membership as well. I spent the remaining years of my sentence drafting youth programs based on the needs that I had as a child and how those needs could be addressed for children in situations similar to mine. I was fortunate enough to have a parolable sentence, and on my 3rd visit to the parole board, after I had served 10 years, the Board of Paroles granted my release. After I came home, I wanted to prove my worth and the depth of my change. Some of the ways that I would service my new community were through volunteer violence prevention and intervention program. I became a member of AmeriCorps community health groups, where I gave the idea to a local clinic chain to place ideas inside of high schools and middle schools to deal with youth who join gangs and teen pregnancies as mental health issues, because I understood that as a child, I was severely depressed going into prison. How can you not be depressed seeing your dad beat your mom on a regular basis and there's no place for you to cry out? There are no counseling service offered to you. All you can do is sit in the back of the room or in the back of the classroom and be silent. My original 25-year sentence expired March 23rd of 2016. I had no infractions during my 12 years of parole. Around that time, I joined the Campaign for the Fair Sentencing of Youth, where we worked to replace life without parole sentences and other extreme penalties for children with age-appropriate accountability that accounts for children's experiences and unique capacity for change. I am not unique in this matter. I stand before you today as founding member of the Incarcerated Children's Advocacy Network, ICANN, a national network comprised of and led by individuals who went to prison as children for severe crimes and are now home living productive lives as elementary school teachers, substance abuse counselors, paralegals, entrepreneurs. And out of the 600 plus youth around the country who were sentenced to die in prison, 140 plus of those men and women are active within our network and within other communities. All of our members were charged with homicide-related crimes and faced with life without parole as a child. We are not monsters. Yes, we made critical errors in our judgments as adolescents, but we are more than the worst thing that we've ever done. We just need an opportunity to prove it. North Carolina is in a unique position. And you have the US Supreme Court on your side that has already passed a decision saying that unless these children are rare, and trust me, the parole board and prison officials would see those in the inside that are not capable of coming home doing things similar to those that myself and those within the ICANN network have done. The parole board, for me, provided a safety net for society. It provided a safety net for prison. And the 3 times that I went up, I can look back and tell that they were assessing whether I was a viable citizen for release. I think they allowed me a chance to mature. But the thing that I'm seeing around the country that Tennessee did right for me, that is not happening for others. I'm seeing men and women who go to prison at 14 and 15 years old, and they are coming home in their late 50s, some in their early 60s. Their life has pretty much been spent in prison. And the thing that they are hearing from employers and others in society, you are too old. You have no work experience. That's a double slap in the face for a child that has never lived, that has never worked, that has never driven, that has never had a chance to vote. All those things that have been stripped away from them because they were a teenager. Now to be in their late 50s and 60s to be told that they are still worthless after, in their mind, they've served their time, they've paid their debt to society. I was fortunate enough to come home young. I've had 16 years to put my life back together. I want to take this opportunity to show you all some pictures of the work that I've done over the years, so that you'll know that I am not, just sitting on this call sharing things with you all that are not true. I want you to see for yourself. As soon as I can get this right, or not. I think we got it now. Sorry about that. Can you all see that?
In about 3 more minutes too, okay?
Okay, 3 minutes. So I want to share some of the slides of, the work that I was doing. A local newspaper saw the work that I was doing here in Nashville in the community for the YMCA, for the metro schools here in the city, as a volunteer. And, they began to, follow me and document the work that I was doing. I went into the school system, work with youth who were red flagged for juvenile lockup. I went into the homes. I presented my own program to the YMCA for young men who were red flagged for juvenile lockup. And we worked with them in the home, in the school system, and then, in the community. All the places that, I fell through the cracks to make sure that these kids had the wraparound services. I'm saying all this to say that those on the inside have some of the solutions to some of the ills that we see in our inner cities and some of our neighborhoods and some of our communities. And if they are giving a second chance, the way that I was given a second chance, they can come home. This is a picture of the, some of the ICANN members, men and women who were released around the country. As Preston said, we travel a lot. These men are from all ends of the United States, men and women from all ends of the United States who are now home. So again, I'm not a lone wolf out here doing this work saying that children can change. Again, there are 140 members of the ICANN network, to show you that these men and women are capable of changing and, need that second chance. I end this by saying I am a father. They are, my wife and, my 2 daughters, and, the young man in the gray was, once a youth in my program. I adopted him at the age of 12. He was red flagged for juvenile lockup. I'm proud to say that now Adam is a graduate of high school. He's in his 2nd year of college, something that I never had a chance to experience myself. I went to prison my high school year of school. The only college that I had was correspondence. This kid had a chance to do both, actually set his foot on the college university and not prison. So again, I'm saying that if some of these other children are allowed to come home, they can really help change society at large. So thank you all for having me, and thank you all for listening to me rant. And oh, the guy on the other end is my co-founder of ICANN. That's Xavier McElrath Bay. A lot of you guys may have saw some of his TED Talks. But thanks again.
Eric, thank you. Sorry, Karen, but really appreciate the personal stories make all the difference, and everything you're doing. And from what I understand, Eric and Preston, you all go throughout the country and offer free training to parole boards. Is that right?
Yes, ma'am, we do.
And,
Parole boards, APAI as well.
okay. We may take you up on that. Let me just ask, and I know we're running out of time, but it's just so important. We're getting all this information. We're probably going to schedule another meeting to digest it and talk about it, but we'll get to that in a minute. But Ben Finholt has been here the whole time. Ben has worked on juvenile life without parole in North Carolina. He's legal counsel with Prison Legal Services. He wrote a fabulous article with Brandon Garrett, Duke University, on juvenile life without parole in North Carolina. And Ben, do you have a few comments, things you would like to have us look at?
Yes, and thanks for having me. I really appreciate it. I think the first thing I want to echo is the sort of racial breakdown data that Billy gave us earlier. In the JLWOP sentences in North Carolina, 94 of them have ever been handed out. 91.5% of them were to people of color. 91.5% of the youth that we decided should never be part of society again were people of color, and only 8.5% were white. I mean, that's just terrifying. And 9% of those were Black kids. So right now we've got 49 kids serving JLWOP in North Carolina, and only 10% of those are white. So even after things that we've done, we've still got 81.6 of these who JLWOP are Black kids, and 90% are kids of color. So I think that, one of the things that if we're going to talk about JLWOP, there are many, many real good reasons not to have it. It's really resource intensive. These hearings that you have to have in these JLWOP cases are like slightly smaller versions of capital sentencing proceedings. So they require time, they require money, they require energy from all the parties. I mean, the cost estimates are somewhere between $20,000 and $50,000 per hearing. Want to continue to impose JLWOP on kids at horribly, basically racist. For the old kids, have to prepare for them. Defendants counsel is required. Counsel gets mitigation specialists, psychological experts, and victims in these cases are forced for a second time. So all of these resources get expended. Whereas somebody who's out on parole supervision, it costs about $2,000 a year for us to supervise them. It costs about $37,000 a year in a prison. So it's $35,000 a year that the state is saving. In 50 years, which if you're doing JLWOP, you're going to be in there in 50 years. If you do a conservative rate of inflation of 2%, it's going to cost $95,000 a year to house somebody who went in as a juvenile and may have reformed themselves, but we'll never know whether or not they have, because we're not even going to give them a chance. So we've got 47 people right now who would be impacted by the change of eliminating JLWOP. And we would save $1.6 million in current dollars for every year that one of those 47 people does not spend in prison. And so Representative Maury mentioned Brandon Garrett, and I wrote a paper on this. Brandon Garrett also authored a fiscal impact letter for the elimination of JLWOP. It estimated that for 87 people, we would save about $126 million. That number has probably dropped a little bit. If we're down to, even for the 47 people who still have LWOP, we would save in the neighborhood of $70 million if those people were able to get out even after 25 years, which I would submit might be too long to begin with. They've done some research on this in Philadelphia, and a recent report shows that they have saved, in the first decade, they will have saved $9.5 million. And yet, of the juvenile lifers who have been released in Philadelphia, only 1% have ever been convicted again. So this is a safe thing to do. Also, there's no data showing that there's going to be a public safety risk by letting juvenile lifers out of prison. And then the last thing I'll say, touching on the points that Eric made, is that, the Supreme Court has acknowledged in a whole series of cases that it is difficult even for psychological experts to differentiate between someone who is quote unquote irreparably corrupt. Reject wholly anyone who's 15 or 16 that they're irreparably corrupt and they deserve no chance. But if a psychological expert can't do it, I don't know who can. And so I think that there are a whole host of reasons that we should not continue to impose JLWOP on anyone, and that we should take a really hard look at why we continue to spend time, energy, resources to perpetuate a system that totally degrades our communities of color and tells them overwhelmingly that we care less about the lives of their children than the lives of white children.
Thank you, Ben. Really appreciate it. We'll try and get this on the SharePoint, the article. And I think the bill we introduced was to have at least a 25-year review, that if a youth had a boxcar sentence or life without parole, that should be changed by statute. I think there have also been ideas for the governor to grant clemency to some of these juveniles that have served a substantial amount of their term, that have de facto life without parole, or in fact, life without parole. We're running to the end. Who would like to ask any questions? Jackie's still here, Billy, Ben, Preston, Eric. I know we've sure heard a lot. We've gone full speed ahead, but anybody have any questions they'd like to bring up? Okay. Well, I think it was amazing, the whole afternoon. So we are looking at the discretion at the front end, and then at this back door, these transfers to Superior Court. Tally, you're here. You had a couple of great points you sent in an email. Would you like to say anything, especially with disability rights?
Sure. So hi, everyone. I'm Tally, and I'm on the task force and in working group 2. We've had sort of a similar charge because we've been asked to look at school resource officers, and have also spent a fair amount of time looking at school justice partnerships. And so in the process of doing that, I've talked to a number of folks. And so I sent Representative Morey an email yesterday, just raising some things that I had been hearing that were a little more related to your working group than our working group. So I'll just read those real quick. One of the main comments I've heard about raise the age, and we heard a lot about it today, but that there was a lot of services that were sort of attached to that, but that the funding didn't necessarily sort of go along with the expectations that was necessary to make the services and the implementation as successful as need be. And since Billy, you're here, you know much more about this than I do, but it's just a comment that I heard sort of regularly from advocates and stakeholders. So shared that, and certainly, my sort of thinking about that is that we want to make sure to recommend something around that funding. On another topic, we looked at crisis intervention training and CITs, and also there's a similar program that the Autism Society of North Carolina does, training law enforcement around autism and other developmental disabilities. But what I've heard from several folks is a need for court personnel and judges to also have training around mental health and autism. And, one of the things I certainly experienced in the state where I came from in Georgia was the core personnel who are on the front lines are sort of really desperate for some just ways to bring down the temperature when things arise, when folks go to court, back in the days when we used to actually do things in person, which hopefully we're going to come back to soon. And then third was that, and Billy, you would know more about this as well, but that there's a mental health treatment that's been used with kids in foster care custody And it sounds like it's also sort of a wraparound for families, intensive alternative family treatment through Medicaid. And they're starting to come up with something similar for kids at risk, at least in Mecklenburg, but that is a valuable sort of mental health service. And I didn't know if there was something that sort of, if it made sense for that to go further as a recommendation for other children or not, but it was just something that struck me as, moving from Georgia, we didn't have that. And there was a lot of need and a lot of kids who were really struggling. So I was just very interested in that one. And the last thing I'll say is, we did make a number of recommendations that I'd be happy to share at any point on the SROs, and it's sort of cross here. But one of the things we really focused on in our committee and our working group that I think Secretary Hooks would want me to share is that we were really up through the schools and not necessarily focused on what you're focused on, which is, when we talk about schools and juvenile courts, the juvenile court side, except that we recommended school juvenile court partnerships really get implemented and move forward. And I think that really ties into Billy's recommendation around the state committee or working group that he mentioned in his presentation. But one of the things that we're really interested in is data. And we did make a recommendation that does cross into your area, and that is that there be some sort of searchable dashboard that's easy to search. And I gave an example again from Georgia of where you could look for every school and every school system, how many kids were receiving in-school suspension, out-of-school suspension, sent to alternative school, homebound, but then juvenile court referrals and some of the information that Billy shared around the school referrals into the juvenile justice system. And, I think that probably would take some effort to sort of make it work between the school systems. But I think having that dashboard and a searchable way to really look at what's happening to kids all the way from in-school suspensions through juvenile justice referrals would make a big difference. And so we've made that recommendation in our working group too, but I wanted to make sure y'all were aware of that. Thank you.
Great, thank you. Any of our working group members? Jim, Tara, Senator, Ronnie?
Representative Mori, I have a question for Jackie. Jackie, I appreciate your presentation. Thank you so much. It's great to see you on here. Thanks for all that you do as well. And thanks to all of our presenters today. It was great to hear from all of you. I know you mentioned that it feels like business as usual, and that's exactly what I thought with these indictments, with these juvenile cases. Do you see any prosecutors' offices across the state that are actually having probable cause hearings and then going that route, or is it automatic? Because I believe in Mecklenburg, it's automatic indictments as well.
Yeah, so Billy might have data on that. I don't have data on that. I can tell you that I get 0 questions about probable cause. And all the questions I get are about the indictment process. And I think that makes a lot of sense because it's way easier. And they need the indictment in Superior Court anyways. So, I mean, it's always been that after a case got transferred, the prosecutor would have to go get an indictment once the case was in Superior Court. So if I were a prosecutor, I would want to use the indictment too, because I don't have to have a hearing. I get to go to the grand jury. It's way easier, and I'm going to have to do it anyway, right? So might as well get it done now. So I think it's just a super attractive alternative for a prosecutor. But I don't know, Billy, if you have the data.
I'll tell you that I haven't seen any probable cause hearings for transfers. Now, there may have been a couple that are in there. We do see a couple of times where there's both an indictment and a probable cause, and we're not quite sure what's going on there. But it is showing up in the data in a couple of places. My guess is that when you get an indictment, not only does the most serious offense get transferred, but all the other smaller offenses get transferred too. So some of those probable causes could have occurred on the lower offenses beforehand. And I'll just say, I was there when the decision was made about probable cause and indictments in the process, and it was a fig leaf that was given to basically give us a chance to get raise the age passed. A lot of the prosecutors said that doing probable cause would have just was too cumbersome on the process. Now, every juvenile case must have a probable cause. There's no such thing as indictment in juvenile court. And so this is a whole new idea for us, for our workers in trying to understand what an indictment means versus what we've always relied upon, which is probable cause.
So it's been a little while since I checked out some of the other states and the reforms they've made. I know Connecticut and Vermont have been at the forefront of a lot of this work. Because when I'm looking at, because that's exactly how I felt when you said it, Jackie. It feels like business as usual. So it really feels like we really haven't raised the age. I wasn't there initially when this passed. Thankfully, it's implemented. But I don't feel like it's gone far enough. But as far as any particular states that you think that you would encourage us to look at models for to actually do this correctly. I know funding is a different issue. So there's funding, so you make sure you do it right. Secretary Lassiter, don't want to stress your folks out. But at the same time, we got to do the right thing, no matter how much work it is for anyone, because we see the failures. We see our failures in a lot of the data that you guys all shared today, and even some of the stories that we've heard today. So do you have any folks, either of you, that you would recommend that we should look at to actually have raised the age without these exceptions?
I can get you some states. I know Connecticut was the model that we kind of built our model off of, but there are several others that have done a really good job of looking at that particular issue. I can't remember them off the top of my head, but I will send them to the group and get them to you.
And I almost think that our own state's model for 13 to 15-year-olds is a good one, right? I mean, it worked here for a long time and still working for that group. And, and the mandatory transfer bucket is this big. And maybe that's not going to, not sellable for the 16 and 17-year-old population, but maybe there's a middle ground, or maybe there's a way to build discretion into some of that decision making. So I feel like maybe we even have a model right here. We just didn't use it.
And I can just tell you, Senator, in Wake County, they've had 29 of these cases, and they found a way to plead 27 of the 29 down to something else, so they didn't have to do the automatic transfer. And so that's how some of the prosecutors that are looking for ways to get around it are doing it. But there's also the remand. There's a way to remand it back down. But that's complicated because it's already gone to adult court at that point, and it's got to get agreement from both the DA and the juvenile defense attorney.
Just last thing, Secretary Lassiter, I know you talked about how African-American children are accused much more, and you got a lot more closed cases for them. I kind of have an idea why that's happening, but just so for the folks that are listening, can you share with me why you think that is, or some of the factors, or are you guys tracking any particular factors why there's a lot more African-American cases being shut out because they weren't sound complaints?
You're talking about the ones that are
closed for insufficient evidence or whatever.
Yeah, I think that we find that the African-American kids often get cases that come to our system that are not legitimate cases to begin with. They're not actual criminal offenses, or they're not offenses that really need to be coming to the attention of the juvenile justice system. So for the most part, that's what we're seeing. And a lot of those we're much more likely to divert school-based offenses for African-American kids, or actually close them. But we also get several in the community that are things that, other kids wouldn't have gotten charged with. And so, and there's no legal sufficiency to move forward with those cases. And that's often what we're finding with those closed cases.
Thank you, Secretary. Thank you all. Appreciate it.
Thank you, Senator. I agree.
Go ahead.
We're going to have to wrap up. It's a little bit over time, but I think following the discretionary transfer and the mandatory going right to a grand jury may follow some of the same counties that impose juvenile life without parole more than other counties. I mean, I think there are great disparities in our state. Wake may be doing it right in trying to get lesser charges, but I think it's an issue that we really have to address. It was one I fought against, including in the raise the age when we passed it, but I think we went way too far in those automatic A through G transfers. Really appreciate everyone. Thank you so much for everyone's time. For our work group, we didn't have time to discuss much, and I'm wondering, most other work groups are adding meetings, and if people are available a week from today at our regular time, We could try and do it in an hour. I know we have some things left over from our bail pretrial. But if we could discuss some of these juvenile issues and come up with our concepts for recommendations. Billy gave us a lot, Jackie gave us, and of course, the juvenile life without parole. If we can discuss that and see if we can think about recommendations. Would you all be available October the 7th at 4 o'clock?
That works for me, Representative Moore.
Thank you, Senator.
Works for
Uh,
me.
It won't work for me. I have a board meeting next Wednesday, the 7th. And it's gonna run right up to 4 o'clock, and then I got one at 7 o'clock. And I'm gonna be out of town at 4. What I try to do is I may not be able to come on exactly 4, but I may be able to come on maybe 15 minutes late or 10 minutes late.
We don't want to lose you, or is there a better time? Is the day before or the day after?
The day after is better for me. I got something both days,
Thursday.
6 and 7.
Okay, would Thursday the 8th at 4 o'clock work for our working group?
Works for me.
Yeah, that does not work for me. I've got another task force meeting on Thursday, the 8th.
Okay,
Yeah, I have a meeting then too.
okay. How about anything on Monday, the 5th at 4 o'clock?
I can't do that. I've got an event for Mr. Josh Stein.
What if we did Thursday, but started at 4:30 instead of 4?
Would that work, Commissioner Smith, at 4:30?
Yeah, Thursday is fine for me, Thursday.
I'm talking about Wednesday, keeping our regular day, but starting at 4:30 instead of 4 to give you a little bit of extra time to get on.
Okay, 4:30 would be fine. I'll just have to, yeah, I can do it from a remote location. Oh, that'd be fine.
We're sorry, but everyone is important, and we appreciate it. Okay, so we will see.
Yeah, 4:30, I can work for 4:30.
October 7th at 4:30. We'll try and keep it to an hour and get you some information, but thank you all very much.
Thank you, everyone.
Appreciate it so much.
Thank you.
Thank you.